A document called the Certificate of Need helps block innovation in North Carolina healthcare, and that's just one way in which government interventions are dampening down the healthcare innovation in North and South Carolina. Our next guest is an expert on these topics. Josh Windham is an attorney at the Institute for Justice. IJ is working on cases in both these states dealing with healthcare and government rules that block innovation. Thanks for joining us.
Absolutely, Mitch. Thanks for having me.
So, first of all, tell us a little bit about what's going on here in North Carolina and your case there.
Sure. So Dr. Singh is a general surgeon in Forsyth County, and last year he noticed that his patients were coming back to him whenever he would prescribe them a diagnostic scan and say, Dr. Singh, I can't afford this scan, or I can't figure out what the price of this scan is. And like any good doctor who wants to serve his patients, he said, I'm going to do something about that. So he decided to open Forsyth Imaging Center, which is a full-service diagnostic center. He got an X-ray machine, he got a CT machine, he got ultrasound machines, but he found out that he was banned from getting a specific type of machine, an MRI scanner, under something called North Carolina's Certificate of Need law, which in short bans healthcare providers from acquiring new equipment or facilities unless they can prove need for those services beforehand. And often they're not even allowed to apply for a certificate of need if state planners project in advance that there's no need available for the next year.
And they need to convince state regulators that there's a need. It's not that just they prove it to their patients, prove it to potential customers. They have to convince someone within government that there's this need.
Yeah, it's sort of a two-track question because every year a bunch of central planners in Raleigh get together and release this document called the State Health Facilities Plan, which says for the next year in each what they call planning areas whether a new service is actually needed. If they don't project a need using their magic formula and their calculators and their formulas, the provider can't even apply for a con to provide those services. Now, if they do project a need, the provider still has to then file this very complex and expensive application demonstrating affirmatively that they actually meet the need requirement. So it's sort of a two-part question.
Now, you were working with Dr. Singh, who you mentioned, Dr. Gajendra Singh out of the Winston-Salem, Forsyth area. Where do things stand with that case?
Yeah, so we actually filed the case in July of last year. And since then, the case has sort of been stalled a bit because it involves a facial challenge to the validity of a state statute. We have to wait until we're appointed a 3-judge panel by the Chief Justice of the North Carolina Supreme Court before the case can proceed. So while the government has moved to dismiss the case, there hasn't been any briefing, and we don't have a briefing schedule on that. There's a bit of an administrative backlog on this 3-judge panel thing.
We are chatting with Josh Windham, who is an attorney with the Institute for Justice. You are also working on a case dealing with health care and dealing with government rules and regulations in South Carolina. Tell us about that.
Yeah, so that case involves a company called Visibly. Now, when we filed the case, it was called Opternative. But here's the basic story. Dr. Stephen Lee was a practicing optometrist who had conducted over 20,000 refractive eye tests and determined that the traditional method of getting one of these tests, of going into a brick-and-mortar optometry shop, of looking through that big clunky device with all the lenses on it and saying better or worse while you stare at that chart from the 1950s, was needlessly time-consuming and inconvenient for patients. And he said, why don't we take this same self-reporting principle at the core of these tests and with 21st century technology allow patients to take an online test from their home? And so he actually developed software that allowed patients to do this, and in 2014 released the world's first online refractive test. And it actually works, but the problem is that when patients take that test, what are they not doing? They're not going into a brick-and-mortar optometry shop, which is how optometrists make all their money. So when the technology went live, optometrists across the country lobbied in states to get the alternative technology specifically banned, and in a few states they succeeded. So in South Carolina, they got a law passed that specifically targets and bans alternatives technology, prevents physicians from actually using that technology as part of their practices, even if it would meet the standard of care to do that, while allowing every other kind of doctor in the state to use telemedicine to treat their patients. So it singles out ophthalmologists who want to use alternatives technology.
So Institute for Justice and your client are challenging that restriction. Where does that case stand?
Yeah, so we challenged that restriction in 2016 under the South Carolina Constitution, and we're on appeal right now before the South Carolina Court of Appeals. The trial court dismissed our case at the motion for summary judgment stage, actually, after discovery, saying that we lacked standing to sue, which I think is completely incorrect and indefensible. It's one of the worst reasoned opinions I've ever read. So we're looking forward to that one.
Now, we've talked about North Carolina and South Carolina. Institute for Justice works with clients really across the country.
Right.
Do we see this type of activity, the government getting involved with healthcare and blocking these innovative procedures in other states? Is this a common problem?
Yeah, I mean, just to give you one example, to go back to the context, I mean, 34 states and D.C. have certificate of need laws of one form or another. Now, North Carolina has one of the more restrictive laws in the country, but protectionism in the medical industry is incredibly common. Basically, wherever you have professionals and large amounts of money, you're going to find people rent-seeking and working to use government power to tamp down either current or future competitors, and that's what we see all across the medical industry.
Why is this something that's so important to the Institute for Justice to deal with this type of case?
Yeah, it's a great question. And this is kind of maybe this is a personal perspective, but in my view, the freedom to direct our healthcare decisions is crucial to our ability to live. I mean, my ability to work with my doctor's freedom to recommend the treatments that are available or that he thinks I should consider trying, that relationship is very important to my ability to direct and to self-determine the course of my healthcare decisions. And when government interjects itself in that process and tells either the doctor or the patient no, people lose quality of life and they lose their lives. And too often that happens not because of a concern for patient health, but because some group was successful at lobbying legislators to protect their bottom line.
We've talked about a couple of cases in North Carolina and South Carolina that are still ongoing. North Carolina hasn't really gone very far. South Carolina, your first step was not a positive outcome. Are there other places where these rules have been challenged, health-related rules, and you've seen some successes?
Yeah, I mean, one example is in North Carolina itself. In 1973, the North Carolina Supreme Court struck down an almost identical version of North Carolina's Certificate of Need law, and our challenge is designed to replicate that in the North Carolina Supreme Court. So we're hoping and expect that that decision will be binding and control this case.
When you talk to people about these cases who are outside the legal field, outside the healthcare field, do people say, wait a minute, the government really does that?
Yeah, I think the most common response I get is sort of one of two responses. One is, like you said, what? Like, that can't be real, right? And the second one is, isn't this a free country? And my answer is, well, yes, it's real, and yes, it's a free country, but something's not adding up. I think, unfortunately, we have a healthcare system in North Carolina that looks too much like a Soviet-style system, but the motivation for it, I don't think is as pernicious as the Soviet one, in the sense that you have well, I think it really just comes from it's sort of a different kind of motivation. It's one group thinking they can block competitors and use government power to do that. So I guess it is as pernicious as the Soviet-style system.
And others who think, whether they're right or wrong, that, hey, this is helping consumers by having the government involved.
Yeah, that's right. And I think one of the things that is most surprising to me about doing research for this and learning about con laws and filing this case is just sort of recognizing the kind of hubris of a central planner who thinks that they can project for an entire planning area or for the entire state what healthcare services are going to be needed. I mean, one of the craziest juxtapositions about this NC Con case is that Dr. Singh knows real people who actually need his services and want his services, and he would love to provide them, but the Certificate of Need law isn't allowing that, and that seems to me crazy.